Everyone thought this story was finally slowing down, but what was just filed into court has quietly reopened everything. And what most people have not noticed yet is what is missing, not what is written. Because entire pages are now blacked out, and buried inside those missing sections is a narrative shift that could completely flip how this case is viewed. And today, we are breaking down what was filed, what is being argued, and why the next ruling could change everything. Everyone thought the story had already reached its peak and that nothing more shocking could possibly surface. But behind the scenes, new documents were quietly filed, and when those filings came to light, the reaction from legal observers was immediate confusion, disbelief, and unanswered questions. Because what appeared on the surface as a routine procedural move quickly revealed itself to be something far more complex and far more unsettling. Entire pages were darkened out, entire arguments were hidden from view, and key portions of the narrative abruptly vanished into redaction. And when that happens in a high-profile dispute, it signals one thing: something inside those blacked-out sections carries weight, and that weight could shift everything. And what makes this moment so powerful is that it arrives at a time when public opinion is already fractured and loyalties already formed. And yet, the very foundation of the legal fight now hangs on technical questions that few outside the courtroom ever notice. Questions about jurisdiction, questions about authority, questions about whether the court even needs to look at evidence at all, or whether the case could be decided before a single witness ever takes the stand. And that the center of this fight is a response filing that attempts to redirect the judge's focus away from defects in the pleadings and toward disputes of fact. Because if the judge rules on pleadings alone, then entire claims may disappear instantly. And that is why the strategy now turns toward insisting that only a full trial can resolve the differences in versions of events. But that argument itself rests on a fragile bridge, and that bridge is built on whether certain laws apply where the events took place. And what begins to emerge as you move through the response is an urgent effort to tie everything back to California, even though key events unfolded elsewhere. And that effort is not subtle. It is deliberate and repeated, because if that link breaks, then the legal framework collapses, and the entire case pivots in a new direction. And what makes this even more intense is that while these technical legal battles are unfolding, the narrative itself is being reshaped, line by line, allegation by allegation, example by example, all with the goal of constructing a story where responsibility flows in only one direction, and that direction is away from one party and toward another. And to do that, the response does not rely solely on first-hand claims, but expands outward, invoking experiences of others, mentioning disputes involving people who are not plaintiffs, not accusers, not litigants, but whose stories are introduced to give the impression of a broader atmosphere. Because when you suggest that many felt tension, you do not need each of them to stand in court for the impression to settle. And this is where the tone of the filing subtly shifts, because it is no longer just about what allegedly happened to one individual. It becomes about what allegedly happened around her and how that surrounding environment is framed as supportive evidence, even when it remains legally disconnected. And as that framing takes hold, the narrative begins to blur the line between direct experience and interpreted experience, between personal claim and collective atmosphere. And for viewers following this story from the outside, this is where confusion often sets in, because what feels emotionally compelling does not always align with what is legally decisive, and yet both are being braided together into a single unfolding storyline that now plays out across filings, press coverage, and public debate. And as this braided narrative grows more complex, one theme returns again and again: control. Who had it? Who exercised it? Who challenged it? And who was denied it? Because behind every cited disagreement, behind every tension described, lies an unresolved question about authority and entitlement. And this is where the history of the production itself becomes central, because the project did not emerge from a massive studio machine. It emerged from a smaller production entity that owned the material, but was widely perceived as inexperienced. And that perception alone influenced expectations across the set. Because when people believe leadership is green, they often assume leadership is flexible. And when flexibility does not materialize, frustration builds. And that frustration quietly becomes grievance. And grievance over time becomes narrative. And the narrative now being presented to the court leans heavily on that foundation of perceived inexperience, as if to suggest that ownership alone was not justified for authority. And that expectation shaped many of the conflicts that later surfaced. And as these conflicts stack one on top of another, the story no longer reads as a sequence of isolated disagreements. It begins to resemble an escalating power struggle, where each denied request deepened the divide, and where disappointment fed into mistrust, and mistrust into alliance shifts. And this is the point where private discussions become influential, not because they are documented, but because they are repeated. And when repetition replaces verification, reality itself begins to fracture. And the deposition testimony later confirms that some individuals distanced themselves not based on direct experience, but based on what they believed had transpired. And that single detail exposes the invisible current beneath the entire conflict. Because once belief takes hold, behavior changes, regardless of whether the belief is accurate. And professional relationships are especially vulnerable to this dynamic, because proximity matters. And once distance is introduced, collaboration deteriorates rapidly. And the legal filings quietly acknowledge this unraveling while attempting to assign its cause to only one side. And as that attempt unfolds, it becomes clear that what is being litigated now is not only conduct, but perception. Because the court is being asked to decide not only what happened, but how it was experienced by different individuals, and whether those experiences can be legally woven together into a single theory of harm. And while that legal question remains unresolved, the public narrative continues to evolve, fueled by selectively released excerpts, heavily edited summaries, and commentary that often blurs conjecture with confirmed record. And through all of this, one detail stands out with striking clarity. The response devotes far more space to surrounding conflict than it does to the core legal allegation that underpins everything. And that imbalance is impossible to ignore, because when dozens of pages describe tension, but only a few pages address the central claim, it naturally invites scrutiny. And as observers begin to notice that proportion, the focus shifts from what is being alleged to how it is being presented, because presentation itself becomes evidence of strategy, and strategy becomes the story. And now, as the court prepares to decide whether this case survives its first procedural checkpoint, everything hangs in suspension, not on emotional impact, but on whether the pleadings themselves satisfy the legal thresholds that must be met before any jury ever hears a word. And that is why this moment matters more than it appears. Because before any dramatic testimony, before any courtroom confrontation, before any closing argument, the case may already be standing at the edge of a ruling that reshapes everything. And the tension now is not built on spectacle. It is built on structure, because structure determines whether spectacle ever arrives. And that is where we pause, as the filings continue to unfold and the next ruling slowly moves closer. As the narrative continues to expand, the focus shifts from structural authority into the personal dynamics that quietly shape the environment on set. Because what unfolds through deposition testimony and referenced communications is not a single explosive confrontation, but a slow accumulation of friction, where unmet expectations collided with strict boundaries. And as those boundaries were enforced, resentment began to simmer beneath the surface. And what becomes clear is that several individuals entered the production with hopes that extended beyond their formal roles. And when those hopes were not realized, disappointment hardened into opposition. And that opposition gradually found its voice through intermediaries rather than through direct confrontation. And that matters because conflict that travels through third parties transforms as it moves. And what begins as a negotiation quietly mutates into an accusation. And somewhere in that transformation, trust erodes beyond repair. And testimony later reflects that tensions were at times resolved through conversation and apology. Yet those same moments are later reinterpreted through the lens of subsequent fallout. And this retroactive reframing is powerful because it reshapes memory itself. And when memory reshapes, interpretation shifts. And when interpretation shifts, alliances realign. And one of the most influential elements revealed in testimony is the role of communication chains, because several individuals acknowledge that their discomfort or distance emerged not from direct personal experience, but from what they believed had occurred based on reports from others. And once that belief settled in, the decision to disengage from professional collaboration followed quickly. And what the filings attempt to establish is that this disengagement was organic and independent, while others argue it was influenced and coordinated. And this is where the narrative fractures into two irreconcilable versions, because one version frames the distancing as a spontaneous protective response, and the other frames it as the result of deliberate alignment. And what makes this tension so compelling is that both versions rely on subjective perception rather than objective markers. And that means the court is being asked to weigh not only actions, but motivations and belief systems. And those are far more difficult to standardize under law. And as these interpretations diverge, the response filing introduces additional layers by emphasizing that disagreements were not isolated to one individual, but echoed across multiple professional relationships, all frames as evidence of a patterned environment. And yet the absence of formal legal complaints from most of these referenced individuals complicates that effort. Because while their discomfort is narratively powerful, it remains legally detached, and the court must navigate that divide with precision. And what deepens the suspense is that the filings themselves acknowledge that after a certain point in production, the alleged conflict ceased and operations resumed without reported incident. And that admission quietly undermines the argument of pervasive and continuing harm. Yet the response now attempts to reintroduce uncertainty into that claim by suggesting that silence does not equate to resolution, and that harm may persist even when no further reports are made. And this interpretive stretch becomes a pivotal point, because it asks the court to accept absences as extension rather than conclusion. And at the same time, the narrative pivots towards supervisory hierarchy, invoking power dynamics as the axis upon which offenses argue to turn. And here again, the structure becomes contested, because while one side asserts employment authority, the other points to contractual independence and reduced oversight. And this conflict over who held power at any given moment becomes crucial, because many of the claims rely on the existence of supervisory control. And without that control, the legal framework shifts dramatically. And what follows is a narrowing of focus onto a limited set of disputed incidents that are presented as sufficient on their own to justify trial. And yet the supporting testimony surrounding those moments introduces uncertainty regarding context, timing, and consent. And when those uncertainties surface, they do not erase the allegations, but they complicate the path forward, because the court does not evaluate emotional impact alone. It must evaluate whether the legal definition of severity and pervasiveness has been satisfied. And that threshold is not shaped by narrative momentum, but by statutory standard. And what becomes striking is that after dozens of pages dedicated to atmosphere, alliances, and surrounding conflict, only a few pages remain devoted to the central allegation that gives the entire case its legal footing. And that imbalance is not merely editorial. It signals where the evidentiary weight may actually lie and how thinly it is spread. And as the argument transitions into retaliation, the structure flips, because now a longer section is devoted to actions that allegedly followed the initial disputes, including exclusion from opportunities, diminished collaboration, and reputational harm. And these claims are framed as a chain reaction set in motion by the original events. And yet here again, the defense argues that these outcomes are indistinguishable from standard industry response to conflict, and that without a proven underlying violation, retaliation cannot legally attach. And that brings the entire narrative back to its core foundation, because every subsequent claim rises or falls with the survival of the first. And the filings appear acutely aware of this dependency, which may explain why surrounding atmosphere is emphasized so heavily. Because when direct evidence is contested, contextual reinforcement becomes strategically vital. And yet strategy cannot substitute for statute. And as the judge now reviews not the emotional arc, but the legal sufficiency, the question becomes whether these claims independently satisfy the legal bar required to proceed, or whether they collapse under procedural scrutiny. And this moment represents the quiet threshold between story and trial, between conflict and adjudication. And until that threshold is crossed, nothing is determined, and everything remains contested. And that suspense now defines the entire case, because it is no longer about who persuades the public, it is about whether the law permits the argument to advance at all. And as observers continue to debate motives, alliances, and narratives, the court prepares to answer a far narrower question: not who was believed, but whether what is pleaded is legally enough. And that answer will either open the door to full adjudication or close it on every theory that cannot stand on its own. And that is where the silence of the redactions becomes its loudest signal, because what is hidden now may never be tested, and what is tested may no longer shape the broader story. And in that tension between revelation and restriction, the future of this dispute now rests. What happens next is no longer in the hands of public opinion. It is now entirely in the hands of a judge. And one ruling will decide whether this story finally explodes into open court or quietly collapses behind closed doors. And when that decision drops, everything changes.